first major Second Amendment case in decades.
The Supreme Court will be taking up a gun rights case.
Major ruling involving the Second Amendment.
For 134 years, the Ninth Circuit Court of Appeals earned a reputation that gun rights advocates spoke about in hushed, bitter tones. It was where Second Amendment cases went to die. Bring a challenge to California's endless restrictions, expect defeat, question magazine limits, carry bans, or purchase rationing, prepare for dismissal. The pattern was so consistent, so predictable, that lawyers called it the graveyard of the Second Amendment. Cases like Peruta versus San Diego, which challenged restrictive concealed carry requirements, were crushed. Rupp versus Bonta, targeting California's assault weapon ban, met the same fate. For over a century, if your case involved gun rights and landed in the Ninth Circuit, you knew what to expect: delay, denial, and disappointment. Then something impossible happened. On August 14, 2025, the very same Ninth Circuit, the court that had systematically rejected gun rights claims for generations, issued its first ever Second Amendment mandate, striking down a California gun control law. Not a temporary panel ruling that could be reviewed, not a decision awaiting en banc reconsideration, a final binding order that California's one gun per month law was unconstitutional, with no appeals remaining. The graveyard just became a resurrection ground, and what happened next suggests we're witnessing the beginning of the end for carry bans, rationed rights, and arbitrary restrictions nationwide. But this wasn't an isolated miracle. On the same timeline, Minnesota's ban on under 21 carry collapsed entirely. Washington, D.C. prosecutors began quietly abandoning enforcement of outdated carry charges they knew couldn't survive scrutiny. And in Tennessee, courts dismantled the state's expansive, sensitive places restrictions that had effectively banned carry across entire cities. 3 different legal battles, 3 different states, but one unmistakable message: the legal foundation supporting decades of gun restrictions is crumbling faster than anyone predicted, and the implications will reshape gun rights across America for generations. Tennessee fired the opening shot in what's becoming a nationwide reckoning over so-called sensitive places restrictions. For years, anti-gun lawmakers used a simple tactic to gut carry rights without technically banning them: declare virtually every public space a sensitive place where firearms are prohibited. The list grew absurdly long. Schools and government buildings were the starting point, then public transit, libraries, parks, sporting venues, and eventually entire categories of locations. By 2023, you could cross major cities and struggle to find anywhere carry was actually legal. The exception had swallowed the rule, effectively creating carry bans through cumulative restrictions rather than outright prohibition. But the Supreme Court's 2022 Bruin decision changed the rules. States can no longer just declare locations sensitive by legislative preference. They must demonstrate that restrictions have clear historical roots consistent with 18th or 19th century laws. When Tennessee tried justifying its blanket park ban using this standard, history wasn't cooperative. Public carry in open spaces wasn't just permitted in early America, it was expected, even encouraged. In 2025, a federal appeals court struck down Tennessee's park restrictions, and the opinion made clear that vague, sensitive place arguments won't survive without specific historical evidence. This isn't just about Tennessee's parks, it's a legal framework threatening similar restrictions in New York, Illinois, and Hawaii, where lawmakers attempted stretching sensitive places into near-total carry bans. For gun owners, this represents more than one victory. It's a crack in the wall of arbitrary restrictions that, once started, tends to spread. Minnesota delivered the next earthquake, and it spoke directly to a generation systematically excluded from constitutional rights. For decades, Minnesota flatly denied carry permits to anyone under 21, meaning 18, 19, and 20-year-olds, adults who could vote, sign contracts, serve on juries, and die fighting for their country, were told they couldn't carry handguns for personal defense. The justification? Vague claims about maturity and public safety. But history told a radically different story. The Militia Act of 1792, passed by the generation that wrote the Constitution, didn't set the threshold at 21. It required all able-bodied men aged 18 to 45 to equip themselves with muskets and ammunition. That wasn't optional, it was federal law. The founders didn't view 18-year-olds as children requiring protection from their own rights. They saw them as citizens with responsibilities, including armed defense of community and nation. Using that historical foundation, legal challenges targeted Minnesota's age restriction, and in early 2025, courts struck it down. The reasoning was straightforward. If young adults were expected to defend the nation at 18, they certainly cannot be barred from defending themselves. When the Supreme Court declined to reverse the ruling in April 2025, the decision effectively became binding nationwide precedent. Overnight, Minnesota's under 21 ban collapsed, and similar laws in other states became legally vulnerable. This wasn't just a courtroom win, it was restoration of rights for millions of young Americans who, for the first time in decades, could fully exercise Second Amendment protections the founders always intended them to have. Then came Washington, D.C.'s quiet retreat, which in some ways speaks louder than any court ruling. For years, the nation's capital was infamous for aggressive enforcement of technical carry violations. Residents faced criminal charges for minor paperwork errors, a holster that didn't meet precise district requirements, firearms transported across city boundaries with documentation slightly out of order, or visitors whose out-of-state permits became worthless the instant they crossed into D.C. These weren't violent criminals or dangerous individuals, they were ordinary law-abiding people tangled in bureaucratic red tape, yet penalties were severe. Heavy fines, firearm confiscations, even jail time for what amounted to administrative mistakes. After Bruin cracks began showing, judges started siding with defendants in appeals. Courts overturned convictions. By mid-2025, even the D.C. Attorney General's office had to confront reality. Continuing to prosecute carry cases under outdated laws had become a losing battle they couldn't win, so they stopped, quietly, without major press releases or public acknowledgement. Prosecutors simply began dismissing carry-related charges case after case. That retreat said more than any official statement could. Even in one of America's strictest jurisdictions, the government recognized that legal ground had shifted beneath their feet. What once seemed like an untouchable stronghold of gun control was now too fragile to defend in court. All of this traces back to the 2022 Bruin decision, which fundamentally rewrote how courts evaluate gun laws. Before Bruin, judges used interest balancing, weighing government claims about public safety against constitutional rights. Time after time, safety arguments prevailed and Second Amendment protections lost. Bruin tore that framework apart, ruling that modern gun laws must align with America's text, history, and tradition. No more balancing tests, no more accepting public safety justifications unsupported by historical evidence. That standard has reshaped everything. Magazine capacity limits in California, assault weapon bans in Illinois, carry restrictions in New Jersey. They all now live or die based on whether they resemble laws from the founding era. If history doesn't support the restriction, the law fails. Tennessee couldn't show historical bans on carrying in parks. Minnesota couldn't point to any tradition of excluding 18 to 20-year-olds from bearing arms. Even D.C. prosecutors couldn't find historical precedent for treating paperwork errors as crimes. Bruin transformed the Second Amendment from theoretical promise into practical shield, and every ruling since carries that same requirement: demonstrate historical foundation or watch your restriction collapse. This set the stage for what happened in the Ninth Circuit, something that had never occurred in 134 years of that court's existence. For over a century, the Ninth Circuit was where Second Amendment claims went to die. Gun owners knew the odds walking in: delay, denial, disappointment. Cases challenging California's restrictive concealed carry laws, assault weapon bans, and purchase limitations all met the same fate: rejection. But August 14, 2025 broke that pattern spectacularly. In Duncan v. Bonta, the Ninth Circuit didn't just issue a favorable panel ruling subject to further review. It went much further by issuing a final mandate, striking down California's one gun per month law. That meant no rehearing en banc, no endless procedural limbo, no second chance for the state to drag litigation out. The ruling was final, binding, and historic. For the first time since its founding in 1891, the Ninth Circuit Court of Appeals struck down a gun control law on Second Amendment grounds and let the mandate stand without further review. Think about the significance. The very court notorious for hostility toward gun rights became the court delivering one of the most important victories in modern Second Amendment history. Legal scholars call this a constitutional inflection point, the moment when a long-standing judicial trend finally reverses direction. For gun owners, it's more than symbolism. It's proof that the tide has genuinely shifted and resistance is breaking. California's one gun per month law was designed not just to regulate purchases, but to send a message. Rights can be rationed like commodities. Buy one pistol in January, don't even think about purchasing another until February. Judge Roger Benitez, who earlier dismantled California's magazine capacity ban, had warned that rationing constitutional rights is no different than rationing free speech or due process. The Ninth Circuit finally agreed, and for the first time, California's fortress of gun control showed genuine structural cracks. But victories trigger counterattacks. Immediately after the Duncan mandate, California lawmakers pushed AB 1078, limiting purchases to 3 guns per month, technically looser than 1 per month, but fundamentally the same playbook of rationing rights, repackaging restrictions, and dragging litigation out. New York, after Bruen gutted its carry law, simply rewrote it by adding massive lists of sensitive places, subways, churches, parks, entire city blocks, effectively turning the state into a carry-free zone through cumulative restrictions. These counterattacks may backfire spectacularly. Courts are increasingly tired of legislative games attempting to circumvent constitutional requirements. Bruen doesn't allow endless reshuffling. Either laws are rooted in text, history, and tradition, or they fail. By repeatedly pushing weak restrictions that collapse under scrutiny, states risk losing credibility entirely, and each failed restriction strengthens overall precedent for gun rights. These aren't abstract legal principles. They affect real people in concrete ways. Consider a single mother in California who, after surviving a break-in, wants to purchase a second firearm for home defense. Under the old 1 gun per month law, she'd be told to wait 30 days, as if threats follow government calendars. Today, that roadblock is gone. Picture an 18-year-old student in Minnesota walking home late from campus. Before, he had no legal way to carry for protection despite being a legal adult. After court rulings, his rights are restored, aligning with the militia responsibilities young adults carried at the nation's founding. Or imagine a shop owner in Washington, D.C., who for years risked prison over misplaced forms. Now prosecutors are dropping those technical cases because they know the Constitution no longer allows treating paperwork errors as crimes. These aren't theoretical improvements, they're changes protecting real people in real situations every single day. For more than a century, bringing a gun rights challenge to the Ninth Circuit meant accepting almost certain defeat. That 134-year pattern just shattered. Courts are no longer satisfied with political arguments, they demand history, tradition, and constitutional text. Legislatures can't ration rights like coupons anymore. 1 gun per month schemes and endless sensitive place bans fail when measured against actual constitutional standards. Once courts consistently enforce rights rather than deferring to legislative preferences, freedom grows faster than anyone expects because each ruling builds momentum for the next. Tennessee knocked down sensitive place walls. Minnesota restored full rights to young adults. D.C. backed away from enforcement it knew would collapse. California was forced to end purchase rationing. These aren't isolated victories, they're building blocks of a new era where courts protect rights instead of burying them. The Ninth Circuit's transformation signals something larger, a fundamental shift in how Second Amendment claims get evaluated. If history teaches anything, it's that once courts start consistently enforcing rights, freedom doesn't just return, it accelerates. The graveyard just became a resurrection ground, and what rises from it will reshape gun rights across America for generations. The fight isn't over. States will keep testing limits, new restrictions will emerge, and litigation will continue. But the legal landscape just shifted dramatically in favor of constitutional protections, and that shift is only beginning to show its full impact.